want to go too long in giving a lecture on it. I was wondering, hands are already going up, but what kind of questions you have? Yes?
If you don't do anything, can you be charged or litigated for exclusionary zone?
No, the legislature has given you the power here to say you do not have to allow them. They're only eligible for a state license to operate if the municipality has adopted an ordinance. The question is, what's the status of recreational use? Is that the question? There's nothing, as far as I know, that's gotten any more traction than previous measures. It always seems like there's something pending out there, but I'm not aware, if anybody else on our panel is, of any legislation that's really taken off. So at this point, I don't know that there's going to be anything on the ballot this year.
If you were to opt in, can you still choose not to allow businesses into your township when they do apply for a license?
So you're not going to be deciding in this, you're not going to be issuing them the permit. What you're going to have control over is where they're located and generally what requirements they need to follow. So that might be signage, that might be lighting, the kind of things that you would often regulate with businesses in general, what zoning district they're going to be in. But this is not, this in itself, the new law is not contemplating or providing for individual review by the township to give it a yay or nay. This is saying in order for them to get their state license, you need to have an authorizing ordinance that says this is going to be a use that we're going to allow.
But if they're issued a license, then as long as they were in compliance with the zoning stuff, we're going to be allowed to.
Right, you're going to have to comply with your ordinance at that point.
Well, maybe just to clarify, if I pass 5 licenses and there are 10 people that apply, do I have control over the picking of those 10 for the 5 licenses?
So your question is, if you've got, if your ordinance, your authorizing ordinances says we will allow up to 10, or up to 5 provisioning centers, and you've got 10 people that apply to do it, and they've all, it may depend on who gets licensed first in the state.
Okay.
Because they're probably not all going to come through simultaneously, so it may be a race at that level to see who gets there first. Yeah.
On a non-compliant here, you say no, you don't want it in there, but a grower comes in with it's a crop, I want to go under the gap farmer, I want to put them in. Or is there an litigation or what on that?
I don't know that we have GAMPs for medical marijuana. Hey, Mike? There's no GAMPs for medical marijuana.
No, we wrote an article about it years and years ago, about that was sort of the next issue, I suppose, and it still has not occurred, but I can see it coming. Yeah.
Yeah, because to get the right to Farm Act protection, right, you have to comply with the generally accepted agricultural management procedures. But again, then the argument, I guess, is only if there are any, and then if they're not, right? It's an argument that I don't think has been litigated yet.
You're coming to Millington Township tonight.
I am.
With our planning commission on repealing our ordinance for marijuana. Well, my question is what let's say we appeal or repeal that ordinance, which takes care of any businesses. What does that affect the private growers that caregivers, I guess?
Yeah, I'm glad you asked that question. So this is all dealing with this new act, which is focused on the facilities, the dispensing centers. Uses that are lawful under the Michigan Medical Marijuana Act, the 2008 Act, that's all still the same, right? So if they have their card and they have a caregiver providing marijuana to a patient who has a card, this isn't designed to interfere with that or to change that. So that's still going to be a lawful use. So you can't opt out of that. And so I'm really glad you asked that question, because this is just focused on those facilities.
Just to clarify, we just recently, we repealed our ordinance because we had one years ago, thinking it's going to protect us from being able to allow these things going, and it does protect us by repealing this old ordinance.
Well, I don't know what your old ordinance says, so it's kind of hard to...
It addressed in early stages of the law, as best we could at that time, it addressed those type of facilities. But we really don't want them, we thought we had to address them. So we repealed it,
or we don't want anything like that.
Right, so then it sounds like it's putting you kind of back in the status quo where you have no regulations concerning, and more importantly, you have not opted in and you have not authorized the use. So, so that'll put you in a position where if somebody's applying in your township and they go to the state and the state's gonna say, where's your authorizing ordinance? And you don't have one. So they would not be able to get that license then. Yeah.
You spoke to the benefits of opting in, the $5,000 fee and the 25% back from the state, blah, blah, blah. What about the things that are going to be on the negative side, like policing, ordinance enforcement, all the costs and expenses that go with that?
That's right.
Fall line, correct?
That's correct. Even though there may be some financial benefits, there may be increased cost in terms, perhaps, of police protection, fire protection, and things like that. So it's absolutely as well an economic, as well as all of the other factors you may be considering of weighing the cost against the benefits. Yeah.
So the new law, there's no residential, no 20 by 20 barns, and no residential properties can be.
It only speaks in the statute to where growers must be located, so it's still giving you, is that not your question?
Yeah.
Okay, yeah, it's saying that growers have to be in agricultural or industrial. It is not speaking to where you can have other uses. So a dispensing center, a provisioning center, dispensary, you could decide where you want to locate that.
Okay.
You can't say a grower can be in a residential area. Yeah.
Under the 08 Act, we've had a lot of guys in our township that either have a car for themselves or they're a caregiver, and they'll pull a permit for X electric hookup, and then they'll get their own guy in after we put our stamp in it. Have you heard anything about rights of inspection for these guys? Because we have no right of inspection. We draft an ordinance so that we can get in there, because we're having fire issues where they'll hook up a 440 hookup, and then we can't get back in there to check them again.
Yeah, I don't think anything prevents you from providing for inspection or fire safety, public safety requirements that you would impose on other businesses as well, I
Well, if it's
suspect.
out of their house,
Well, if it's out of their house, I guess it's a question, do they have a home occupation? Are they falling under your home occupation ordinance? Or are you talking about, I guess I was
talking about a guy
envisioning.
that he grows with 6 plants or whatever in his house, and he has this electric hookup, which he pulls a permit for, and then he gets his own guy in afterwards, and then we have no right to go back into his house and check it.
Well, I think that you're going to have a distinction between, if that's all under the 2008 Act like you're talking about, and if it continues to just be a use under that, if they're not a facility under this new act, and if there's not some other ordinance, like a home occupation ordinance, then it may put you in a tough spot. But I think if they have a facility, they're running a facility, regardless of what district that it's in, you may be able to fit that into your authorizing ordinance if you decide to allow it there.
Could we enact the home business ordinance for a guy that's a caregiver under the 08 Act for inspection?
Have you had that come up exactly, Mike, with home occupations and medical marijuana? I don't know if we've had anybody do that. I'll put you on the spot as well.
No, I think trying to remember, we did draft an ordinance that would have regulated the use of primary caregivers as a home occupation.
Yeah, that's what I was thinking as well. If what they're doing, regardless of the protections they have, which really are largely from criminal prosecution and other discrimination, if what they're doing falls within the scope of a home occupation, then they would not necessarily be exempt from complying with that requirement simply because the nature of their business is medical marijuana. Yeah. Oh, and I'm being told there's like a cane over here yanking me away from the podium. So thank you. I'll be around as well if you want to bring your questions up.